morning, salam alaikum and namaste everyone. I hope all of you are very well and safe. I take this opportunity on behalf of IBPC to welcome all of you to another webinar in the series that we are conducting. And today is a great opportunity to learn and discuss the topic of law, the legal implications due to COVID-19, and in particular, force majeure conditions that are there in contracts and various contractual issues, which is very relevant for all of us. In order to do that, we have two eminent panelists here. So I also take this opportunity to welcome Mr. Hassan Saeed Abaragh. He is the managing partner of ICLO law firm, and also our own member, Mr. Vivek Agrawalla, who is the partner and head of India service of MAA law firm. Mr. Hassan Saeed Abaragh, who is the managing partner of ICLO law firm, has masters in law from Sorbonne University and another master's from Nanterre University, Paris, in law and legal practice, and has over 20 years of experience in UAE, Japan, Paris, and across GCC. Vivek Agrawalla has over 15 years of experience in legal practice, legal consultancy, and advisory. He has been almost 7 years or more in practicing in Dubai. He's the partner and head of India practice of MAA law firm. To his credit, a number of publications and books connected with the legal issues related to VAT or banking or business related issues. So gentlemen, it's my pleasure to welcome both of you today. Thank you for joining and conducting. And with this, I would like to pass on the mic to Vivek. And Vivek, please carry on the rest of the session. Thank you.
Good morning, everyone. Thank you, Mr. Sinha, for a very generous introduction. I hope all are safe and healthy, all your loved ones, and you are safe and healthy in this difficult times. Thank you for attending this webinar. I am delighted to have this opportunity to speak to all of you on this important topic. In today's session, the idea is to deal with the concept of force majeure in the current situation of pandemic and the subsequent lockdown. And given the event is designed for members of IBPC who comes from all streams and professions and businesses, we have deliberately designed the event to keep it very simple and not use too many legal nuances. We assume most of the attendees may not be lawyers, so the idea is to give a very practical insight into how this concept works and how it could benefit in the current situation. For the today's event, I will speak first 15-20 minutes about the concept of force majeure, its implications generally in certain kinds of businesses. Then I will hand over to my friend Mr. Hassan, who will go a bit in depth into various provisions of law in UAE and also certain judgments. And we have kept enough time at the end for Q&A. We expect to take as many questions as possible. During the session, I will encourage all the attendees to post their questions through the chat box, and we will take up the questions. We will have enough time for that. I'll just quickly share my screen to show what we can expect from this event today. So the main things we would be covering would be understanding force majeure concept, and we will have a look at sample clause, and of course the trillion-dollar question, COVID-19 and the subsequent lockdown and pandemic. Is this a force majeure situation? What are the implications of this for your contract? And then Mr. Hassan will deal in details about implications of force majeure and the remedies available under UAE civil law and UAE courts various judgments if we have on this concept earlier. So this would be the format we will go through this. Let me start on a lighter note. So a few days back, I read a message on a WhatsApp group, which said that somebody said, "I am extremely happy with my married life. It's all going extremely well. But had I known that there will be a day in life when I have to spend weeks together locked down in house, perhaps I would have chose somebody else as partner." Again, I read another message again in Dubai. Somebody said, "My home, I'm extremely happy where I'm living. Everything is fine. But had I known there would be a day like this when I have to spend days locked down at home, perhaps I would have preferred a lesser parking lot and a bigger balcony." This I said in a lighter note, but these are about the wishes of the people. But if you think more seriously in today's situation, the businesses and professionals, what they are going through, for them, it's not about wishes. It's a compulsion. They don't have choices. They are forced in a particular situation where they have to conduct in a particular manner. There is serious liquidity issues, and it has led to unprecedented situations. Certainly, during our lifetime, we have not seen anything like this, and this takes us to today's topic of relooking at the contracts which would have entered into BC. By BC, I mean before COVID era. So when those agreements were drafted, it was a completely different situation. And now you find yourself in a completely different situation. How to deal with that and what are the remedies available? We will go into this bit more into details. Even that, to be honest, even if your agreements were drafted by lawyers, not often this is a clause which is given too much of attention. It is like a boilerplate clause, which means one of the many clauses which are just inserted in a document at the end, and so it may not be well crafted or thought over, but nonetheless there might be a clause, and we will look into that, how to deal with that. Let me come to a few of the issues which I have personally dealt with in the last few weeks, which has an implication on this, and perhaps this will set the tone for today's discussion. So immediately when the lockdown started somewhere around March this year, I got a matter where somebody has booked 700 odd rooms in a hotel in Dubai. The agreement was done in 2019, and this was for a 3-day event in June 2020. And in the March, they already faced a lot of cancellations. The event organizer wanted to cancel the contract with the hotel, saying that we are already facing a lot of cancellations, and it doesn't look like we can go ahead with the event in the month of June. The first reaction of the hotel was tough luck. Your event is in June. We are in March. We don't know. Things might be normal. And if you look back in March and February, we thought it is a matter of few weeks. So they said we cannot go back on the contract. The contract will be cancelled, and whatever advance you have given, that will be forfeited. We had a look at the document, and there was a force majeure clause which was pretty well drafted. I don't know if there was really a force majeure situation in the month of March, but nonetheless, we tried to persuade upon the hotel with the clause, and thankfully they agreed. And they got the result. I think the advance was adjusted for the event in the next year, which is what our clients wanted. Another thing which we are seeing a lot in the last few weeks is about payment issues. There is severe liquidity issues. There are contracts where buyers and sellers have entered into contract, and one party is unable to pay. I faced a very funny situation a couple of weeks back where I got a call about a party who had to pay to somebody, And they said, we are just unable to pay. If something can be done, we can invoke force majeure or something, just to get some more time from the party whom we have to pay. And interestingly, the party whom they have to pay, who was taking a very hard position that you have to pay immediately and we won't give you any time. That same client had called me a few days back because they had problem in paying to somebody else a few days back. So this is a strange situation where everybody is facing the same situation. So we expect parties to be more reasonable. And lastly, last week I got a matter about restaurant business where they are bleeding. I mean, the lockdown is over, restaurants are open in Dubai, but there are no customers. So they have a serious crunch problem, and they made claims against insurance companies, and it was very difficult to get the money. I'll come to that in a bit more details subsequently. So overall, I think if I were to club together all kind of queries we are seeing recently in current situation, I'll put it in two baskets. One is about parties are unable to perform their obligations because of the current situation, which is beyond their control. It is unexpected. So they want some relief because they are unable to perform their obligation. And the second type is where parties are able to perform their other obligations, but they are unable to pay. They are unable to make payment obligations. And maybe this is not directly linked to the current situation, but just there is a serious liquidity crunch and they are unable to pay. So the query we are getting is, can we use force majeure to get out of the situation and get on with life? So hopefully by the end of this webinar, we'll have some idea how to look at these queries. We'll hopefully have some answer, and that's the purpose of this webinar. Now, again, before going to force majeure, I want to tell the audience that as a thumb rule, the parties who enter into contract are supposed to know their contract best. They know their commercial terms, and the courts generally will uphold the contracts the way they are written, because in every commercial contract there is an inherent risk, and parties are supposed to know that risk. They take that risk, and force majeure or similar concept we are talking today is not a remedy for all such situations. So, for example, if I buy a house, I take a position that this is a good time to buy a house. Tomorrow, if the prices fluctuate a bit, we cannot take that as a defense to say that the prices has gone up and or gone down, and I thought it will go up. So every commercial thing is not a force majeure, and you cannot take remedy, and that's very important to know. Now, again, before going into the concept and details of force majeure, another point I would like to highlight is that today's session, my friend Hassan and myself, we will be talking more about legal remedies available because of current situation, either because of the terms of your contract or generally available under law, under UAE law. But in my personal view, in most of the situations, your remedy doesn't lie under law. It lies under, in the current situation, it lies under knowing your contract better and engaging with your counterparty and having a meaningful discussion and settling the matter out of contract. In my personal view, in most of the contracts, we will expect parties to be more reasonable to look at this situation, because the example I gave earlier, it is affecting all the parties. It is not a situation, for example, a party from India is sending some goods to China and there is a problem in India and not in China. This is a situation when there is problem everywhere. Just to give an example, let's see the air travel industry. This situation affects we as a traveler. It affects travel agent companies. It affects travel portals. It affects airports, airlines, and also airline manufacturer. This is a unique situation which affects everybody down the chain. We recently heard about Boeing laying off so many people. So this is really an unique situation during our lifetime, and it has to be looked at that way. Now coming to what I said earlier, the contracts you would have already entered into, and the practical query is how to get out of it and what could be done. So my suggestion would be that before doing anything, one needs to look at his agreement properly. Whole agreements needs to be looked at. If required, you need legal assistance, but that may not be required for all the contracts. The whole agreement needs to be looked at, but one of the clauses you might look at is say a termination clause. There are a lot of agreements where there is a clause which says that you can terminate your clause agreement by giving 30 days notice or 15 days notice, irrespective of any reason. So if there is a clause like this, then you don't need to go into the hassle of knowing details about force majeure and all. You can straight away use that clause and get out of the contract. Next, and of course, the most important thing is force majeure. You need to look at if there is a force majeure clause in agreement. But again, here I want to highlight that having a force majeure clause in the agreement is not necessarily a good news, and not having a clause in the agreement is not necessarily a bad news. Because even if there is a clause in the agreement, we have seen quite often it might be favoring only one party, or what is the implication of that clause, it might not be clear. So just the heading force majeure doesn't help. One has to look at the whole clause, what are the implications. And again, as I said earlier, there is no standard force majeure clause. So what is written there, the court will go by that, and court will upheld the choice of the parties and respect that. So it is very important to see the clause. Absence is not bad news. By that I mean that, as my friend Mr. Hassan will deal in details subsequently, is that even if the clause is not there, there are remedies available under UAE law, and we'll deal with that in more details. Now, coming to force majeure, I mean, there are articles under UAE law which gives the remedy under that, and I leave it to Mr. Hassan to deal with that clause in more details. Now, what is force majeure really? So it comes from French word, and it basically means a superior force or an act of God. Generally speaking, that's the meaning. So the idea is when the parties enter into contract, they may not look at everything which might happen in future, which might prevent one or both parties to perform their obligations. And in a situation like this, how the contract will be dealt with, and that is why the concept of force majeure was developed, to help the parties in such a situation. And there is no definition in the sense activities A, B, C, D is force majeure under the UAE law, though there are a lot of contracts which give a list of the events as force majeure. For example, fire, riot, situation of war. After 9/11, we saw a lot of contracts including the word terrorism, and certainly going forward from now, the word epidemic and pandemic will be included within the definition of force majeure. Quite often there is also a phrase which is used is any situation beyond the reasonable control of the parties. So these are the situations which are broadly included, but bear in mind the threshold is very, very high to invoke force majeure. Just to give the broad points again to summarize what makes force majeure is, number one, it should be unforeseen. The parties would not have expected this. So for example, I gave the example of buying an apartment. This prices might go up, so this is quite foreseen. Prices can go up, we all know that. But this, whether COVID-19 was foreseen, I mean, earlier we had situation of MERS, SARS, Ebola, but in my view, none of them, compared to the current situation, none of them led to such kind of lockdown, border closures. So in my view, this is unforeseen, but we don't know how the courts will look at. It has to be unavoidable and beyond the control of the parties. So this is again very important that parties, if they can mitigate the risk, they have to mitigate the risk. But otherwise, if it is unavoidable, that's another criteria to call it a force majeure. So just to give an example, if today in the current situation, if a party enters into a contract with other party for, say, supply of face mask or gloves in a current situation, so certainly in this kind of example, one cannot take force majeure because of COVID, because you have entered into this contract after this situation and you knew about it. So this cannot be defense. The most important point is how it affects the party's position in terms of impossibility. So this is very important. It should, as a concept of force majeure, it should make your obligation impossible. That's the word in section 273, which Mr. Hassan will deal with. It should make almost impossible to deal with the situation, and then only you can invoke that. And that's where the problem comes. In most of the situations, even if there is a lockdown, but you could perform your obligation, then you don't get benefit of force majeure. So that's the most important point to take note, that it should impact your obligation. So for example, during lockdown here, the construction activity was going on. So for the people in construction, you perhaps cannot take this defense because you could have done your part of the obligation irrespective of this current situation. Generally speaking, the threshold is very, very high. Every commercial difficulty is not a force majeure, and merely commercial difficulty or change in price is generally not force majeure. And usually payment obligations, this again, a lot of audience may be disheartened to hear, but difficulty in payment per se is not force majeure in most of the situations. In fact, I have seen a lot of clauses where it expressly say any obligation which is suspended except payment obligation, that constitutes force majeure. So that's again very important to look at. Then under the law, there is a concept of force majeure, and then there is, which is very good under UAE law, is that there is a concept of unseen circumstances. So there is another section which deals with a situation where it may not be force majeure, but it becomes very difficult for a party to perform its obligation, not impossible. In such situations, the court can intervene and provide justice to the parties. And that's another clause which we would expect to be invoked quite frequently in the current situation. Now, conscious of time, I'll just quickly go through 2-3 types of verticals and businesses where this clause, how this clause is looked at, and then I'll hand over to my friend, Mr. Hassan. So one is trade and supply kind of transactions. There, I think the most important thing would be to look at the clause in the agreement, or what is the remedy given under that. But apart from that, under law, there is an article which says if you have agreed on an agreement for supply of goods and goods is not delivered within the time agreed, then in such a situation, the buyer can refuse to take the delivery, or it can give more time to take the delivery. So this is a remedy available under law in this kind of situation. In loan and financing agreement, in this kind of situation, usually force majeure clause is not there. The reason being, these are straightforward agreements where borrower takes loan and he is required to repay the loan. And as I said, repayment of monetary obligations is not usually covered by force majeure. So this clause is usually not there. And if somebody has taken a loan, he has to repay. And invocation of force majeure may be extremely difficult. Perhaps in the current situation, one can look at the earlier clause, which I said 249, where difficulty might be a defense. Mind you, that's not force majeure, that is unseen circumstances. So maybe one can try refuse under that. Lastly, I will deal very briefly with insurance contracts. Again, I see it is very important for a lot of attendees. So what we have seen is typically in current situation, there would be a property all risk and business interruption risk covered by insurance. And property all risk typically covers things like fire, burglary, any harm to property because of that. Now, the most important thing is business interruption, where you'd expect that because of lockdown, say a restaurant or a shop in a mall, it was closed for quite a few days. Can you take this defense of business interruption? But unfortunately, what we have seen is a lot of times business interruption is linked in the insurance contract to business property all risk. So what it means is, suppose there's a fire in the premises, and because of that fire, if you could not do your business, say for 2 months, then that risk is covered. But in a current situation where there's no really harm to the property, but you are unable to use your premises, technically a lot of this may not be covered by business interruption clause in the insurance policies. But again, like any other contract, insurance is a contract. It needs to be looked into. There are no standard clauses. So we need to look at what is covered and what is not covered, and then see what benefit you could get. In fact, in one of the current situation, I saw that for one of the clients, the policy was due for renewal in the month of April. And when they went for renewal of the policy, in the handbook, there was a clear exception in the name of COVID-19. So it says, notwithstanding anything in the policy, if there is a claim that is linked to COVID-19, it was very wide, then this you don't get a claim basically. I mean, for a restaurant owner, it was like I'm buying a life insurance policy where death is an exception. It doesn't serve any purpose, and that was so express. COVID-19 was an exception to any claim under the policy. So this I mean, these are the kind of situations people are facing, that this needs to be renegotiated, looked at properly, and then get on with that. With that, I will pass on to my friend Mr. Hassan, and subsequently, I hope we have enough time to take your questions. Thank you very much. Over to you, Mr. Hassan.
Yeah. First of all, Mr. Vivek, I would like to express my deep gratitude for yourself, for Mr. Sina, Mr. the Vice President, and all the IBPC honorable members that are attending today's webinar. This is a very important opportunity. And I will try to give you a very practical insight and use some legal background just to clarify this practical approach. We are in a very unique context. Media is relaying force majeure in a way that a little bit goes for many weeks against the deep understanding of the legislator of this very old concept that comes from French law. So in the first weeks, a certain understanding was spread by newspaper, by social media, that this is a big opportunity to review contract or to get out from the obligations. Certain of my clients were not in real difficulty. And they just came to me to ask me, how can we take a certain advantage from this context, even through contract review or amendments? This is not the spirit of the law, and this is not the understanding of the judges in matter of implementation of this concept. So the understanding of this concept is very important, and its utilization also is not as easy as we can imagine. So we have, first of all, to understand that force majeure is a concept that was deliberately not defined by law. Why? Because this concept, when it was set in French law in the 19th century, it was set to give more fairness in the execution of the contract in the future when the parties are facing, in good faith, unpredictable situations. This concept is closely connected to French legal history because the context of the French Revolution changed the history of France and transferred it from a monarchy to a republic, and it impacted for many years the political and economic context in France. So it was agreed since early 19th century that this concept will not be defined. It will be the judge's call to adapt it, to amend it, to redefine it, and to use it in the most fair way to help contracting parties fulfilling their obligations. So this is the historical background of this concept. Later on, in French law, this concept evolved to be part, this is a very recent evolution, early 21st century, this concept evolved to be one of the tools to help parties to have continuity of business. And this is a totally different approach from what we can see and understand in media. It is not a tool that is there to disrupt relation. It is a tool that is activated to readjust the contract, to modify obligations, and to see if continuity can be preserved in the business relation. So this is how the concept was perceived, seen, and implemented by the civil law countries. UAE has introduced this concept in '85, and to came to the perception of the UAE's legislator and judges, it's very important to note that, first of all, the concept was not defined. Secondly, the reference to this concept is in direct or indirect references in several articles. Sometimes we have to combine them to come to a bespoke legal reasoning matching the specific situation. And the third thing is that judges in UAE, both in Dubai and Abu Dhabi precisely, are very conservative in face of this concept. So we have to distinguish between two things: force majeure as a general concept and COVID. So generally, force majeure is something that judges are very hard to convince when it comes to ask them to activate this concept. Why? Because it will lead automatically to a partial or a total extension of the obligation, which is a very irreversible effect of the decision. So this is why judges are asking for factual elements. They are going on case by case approach. They are asking for evidences, and sometimes they go straight forward for experts. And this is also a very characteristic aspect of UAE judicial system. In normal situations, when we are in let's say, construction issues, or when we are even in standard transactions, banking issues, etc., judges will go easily for the nomination of an expert, despite the fact that there is a certain case law behind them, that they will go for expert. In this concept, for a COVID concept, predictably, judges will be very skeptic, for two main reasons. The first reason is that they don't have fresh precedents to look to. And knowing that in UAE, judges are not bound by the precedents. They will have a look to them just to have more or better or accurate understanding of the article that is requested to be implemented. This is one thing. The second thing is that the judges don't have a full understanding of what is the implication of COVID on the business. And it's an ongoing thing. And the exercise that the judges like a lot is to assess the full situation and came later on with a decision. This is an ongoing situation. And the World Health Organization has declared the pandemic on the 12th of March. And we are almost on the third month, and many countries are still in. Some of them are going for deconfinement, progressive deconfinement. So the judge, they don't have this this space to assess the situation. The fact that before going to the judge, an exercise has to be done by the business community. The first one is a general exercise. The second one is a more specific exercise. The general exercise is to review the contracts. And this is what Mr. Vivek stressed just a few minutes ago. The review of the contracts is a very important exercise because we will have two situations. Either we will have a contractual force majeure clause, or we will face a situation of non-contractual force majeure clause. If you have in your contract a force majeure clause, and I am referring specifically to certain contracts, especially food and beverage contracts that have this clause, or even in financial free zones, lease contracts, they used to answer this clause in a very on a regular basis. If you have this clause, it's not enough. So this clause is often drafted by one single party, and it is not drafted based on mutual agreement, because it is classified as a very rare clause or a standard clause. So we have, first of all, to have a look to this clause. If we have a force majeure clause, we have to check what this clause is covering. First of all, is there any express exemption of obligations? This is the thing to which the judge will look directly. Is there an express exemption or not? And if there is a general will or agreement to exempt on certain obligations or listed number of obligations, the third element that has to be listed in this clause is the mechanism. If we take comparison, let's have a look to the penalty clause, for example. In the penalty clause, you will have details regarding the conditions of exemptions, the duration, the amount, etc. If the force majeure clause is not structured in this way, it will be very hard for the judge to implement it directly, and the judge will get back to the law and to this discretionary power and to this conservative approach to see on which grounds he can apply or not this context of force majeure, knowing that we are talking today about COVID. So we will go to ask the judge to apply force majeure or to apply COVID context based on force majeure clauses, and to ask for partial or total exemption from obligations. So this is a very practical and important approach. If we don't have this clause, the exercise will be not easy. It will be not impossible also, but the exercise will go through a path that will lead us to go and bear the interpretation of the judge to the contract, and to have his final understanding of the general context. So in this exercise, the judge will lead, and practically he will depend on the expert's report that will be submitted. This is also why in this context, if there is no force majeure clause and the amount of the contract is very important, our advice is to go for a consultancy report from an expert. So this report will help the judge to understand the context. Even if later on he will nominate a court expert, he will have a basic understanding that will help him to assess the real difficulties that the claimant is facing. So this is the general approach regarding force majeure, regarding also the mind of the judges when they will face it, and we will try to go and to see one other point, second point, which is very, very important and very particular, which is the status of force majeure in UAE law. And this status has this particularity. We mentioned the first one, that there is no direct definition of force majeure. The second one is the fact that we have sporadic articles, which means that we have different articles, and we don't have to go straight forward, pick one article and rely on it and ask for a remedy. We have sometimes to go through a combination of articles to understand them, to apply them to a very particular situation, and to choose the most accurate articles that will help the claimant to expose the sought relief. We will go through those articles in a very brief way, just to give you an idea about the differences of these articles and how will it be useful later on to have a combined approach. So Article 249 that Mr. Vivek mentioned before is a general article. It is an article regarding the hardship, and it is set to a context which is not directly connected with force majeure, but it is connected with the difficulties in fulfilling obligations. So this article is very important because we will have to rely on it or to refer to it on a regular basis, just to help the judge, if he is not convinced about the context of force majeure, to rely on this article in modifying obligations. So this article will be used predominantly as the initial article to introduce the COVID context that will be exposed to the judge. Basically, this article is saying that parties are eligible for a review of their obligations if there is a heavy loss. And this heavy loss has to be proven, has to be exposed on factual basis, preferably with an expert report submitted to the judge. And eventually, sometimes we will have to have two opinions of two different experts if the field is a technical field. We might have the point of view of an accountant and the point of view of a technician, just to help the judge to have a full understanding of this heavy loss. This article is not directly related with today's context, with COVID context, but it is a very important article for the mind of the judge. The article that is highly referred to, not only by lawyers but even in business community, is 273. 273 is related to bilateral obligations, this category of contracts in which, like lease contracts or construction contracts, in which we have two obligations and two reciprocal obligations. And in this context, the Article 273 is opening door to have an exemption or an extension of the obligation, partial extension or total extension. It's very important to mention this option for the judge, because the judge here will rely on a very factual approach of COVID context. We have to take in consideration that this context is a temporary context. We are getting back to business slowly, so maybe within 1 or 2 months we will have a normal flow of business, and the issues that will go to courts, part of them will be related to these 3 or 4 months of lockdown. So most probably, if the contract cannot be terminated, the judge will go for a partial adjustment of the contract or a partial exemption of the obligation based on force majeure applied to COVID context. So this is for 273. We have also a very interesting article, 473, dealing with the impossibility of execution. This is also like 245. This is a general article, and it can be added to 273 and 249 just to strengthen the fact that obligation cannot be executed. We have all in mind the limitation of of circulation, the fact that malls were locked down for many weeks. So this kind of article will be useful also in construction. Specifically when you have 24 hours rotation, when those rotations are limited to 1 or 2 shifts in this case, and a certain exoneration can be requested based on force majeure and the partial impossibility of execution. So we came here to a very important approach that we have to take in mind, which is the fact that we have to not only review the contract, but also choose the right articles and the right combination of articles that will speak to the judge. 278 also with 473 are very interesting articles, but it will depend on the combination and the context. One advice, a very practical advice, when you are dealing with your co-contracting parties and you are evoking with them this COVID context, and you are trying to negotiate with them on good faith in an informal way, just keep with you all the exchanged emails or letters that might mention that there is a certain intention to amend the contract or to agree on a certain postponement of payments or reviewing of obligations. This might be very useful later on to prove the fact that the willing of the parties regarding certain articles has changed based on Article 132. We will come now to the understanding of the court, the recent one. We have court from the Dubai Court of Cassation. We have a decision that was rendered one day before the declaration of the World Health Organization. This decision was issued on the 11th of March 2020. In this decision, the Court of Cassation, Dubai Court of Cassation, the Commercial Appeal section, ruled that the contract shall not be terminated unless a force majeure has occurred that makes the implementation of the obligation impossible. And it is required to invoke force majeure that this force majeure results from an unexpected incident at the time of the contract, which is most probably the case starting from 12 March and going on. And this unexpected incident has to be impossible to be avoided. Example, it cannot be prevented, or its consequences cannot be prevented. The court also mentioned that this unexpected incident has to be unpredictable. So parties, when they sign the contract, cannot predict it normally. This is a strong argument to say that COVID is something that was not unpredictable in 2019 or even before, and all the contracts that were signed before can rely on this impossibility of predictability to go to the judge and to say that we are in this context of unpredictability. And the court also mentioned the criterion for the implementation of those two conditions. The criterion is the ordinary person. This means that the contracting parties has to act in good faith as professionals, and here for businessman, this obligation is tighter than the consumer. So we are under the clauses of the Commercial Transaction Code. So we have to do our due diligence. We have to check all the risks mitigation and sign with a due evaluation of the prospective risks. When this exercise is fulfilled, courts can rely on force majeure. We have to have a very important comment on this case. This case is concomitant or parallel to the context of COVID, but it is not the result of COVID. So up to now, we don't have a straightforward, clear decision from Dubai Court of Cassation or Abu Dhabi Court of Cassation or even the Federal Court of Cassation connecting force majeure to COVID. But given that COVID context is one of the emanations of force majeure, we can still rely on this fresh decision and go to the court and ask for the appropriate remedy. One important remark is the following. When we go to the court, we have to bear in mind that this exercise is a first-time exercise both for courts and parties. So there is a risk. There is a risk in matter of understanding the facts, in matter of applying the principle that was held in March, and in matter of interpreting the articles of law that we just mentioned. So there is no automaticity in matter of applying force majeure. So this is a general approach regarding force majeure. I don't know, Mr. Vivek, if we have still time to go for specific enlightenment regarding certain contracts, or should we give room to questions and answers?
Mr. Hassan, actually, thanks a lot, but we are running little short of time. But before we conclude, I will request you to, if you could have a quick chat on Article 782 regarding leased properties. Yes. The benefit available to the parties, if you could have a just quick overview of that in a couple of minutes, because I believe that might be very relevant for a lot of attendees, which in a leased premises, because of the current situation, you might get certain rental benefits. If you could have a quick look at that.
Yeah, for sure. Article 782 is in Civil Code. And as we know, both in Abu Dhabi and Dubai, we have specific laws regulating the rental disputes. And we have also respective committees that are handling and applying the local laws. In COVID context, it is one of the rare situations in which we will go directly to civil code to invoke COVID context in commercial rentals. So if there is a full enjoyment of the lease, and this full enjoyment is prevented, and we are talking precisely about malls. If it is prevented, then the contract, for example, is ending in June, July, etc., and the notice of termination was sent. So we have also to comply with certain obligations in the law. It is highly expected that the court will go for the application of this article and will terminate the contract, and there will be no renewal or no automatic renewal based on the absence of full enjoyment of the premises. If it is not the case, if we take a contract that was renewed or signed in January or February before the official declaration of pandemic context, in this case, the judge will go most probably for proportionate review of the rent. We have also to highlight one important thing. Tenants cannot stop paying rent because the COVID context. So there is no automaticity and no self-application of this rule. So, given that the enjoyment of the lease is factual and continuous, the payment cannot be stopped. And we have an example in mind. All of us, we experienced the confinement in these few weeks and months, and the confinement was at home. So we enjoyed the benefits of this contract. This is a very important observation, because if a tenant stops payment from his own initiative, he might be defaulting, and he will face a different claim for default of payment. And almost all the tenants, they have checks and they can open criminal case against the tenant and go later on for civil courts for the payment of the due amounts with all the executive process that can harm the business, precisely the business. So this is a very important point that has to be taken in consideration. What is the alternative in this case? The landlords are here in a situation that is between brackets, allowing them to go for an agreed or non-agreed amendment. If they are approached with sufficient proofs, especially in commercial tenancy contracts, this might be very helpful. And I think it's an advice also for our attendees today, a report from the accountant mentioning the volume of loss or predictable loss will be a key element when they approach the landlord to ask for a decrease of rent or for a variation of the agreed rent. This is a very important point, and we have also to be very careful with the criminal side, because for labor law, for example, an amendment of the law was enacted in March. It is not the case for tenancy, at least in Dubai. In Abu Dhabi, there was a circular decreasing the rent for 20%. So based on this element, our attendees has to be very careful, and it's better for them to approach the landlords and try to negotiate a decrease of rent based on factual elements than going straight forward for a claim like it was relied in media for a while, which was not truly right, and created a certain misunderstanding regarding the fact that tenants can be exempted from their obligations of payment.
Thanks a lot, Mr. Hassan. This was very helpful. We are absolutely out of time. I'll request Mr. Dilip Sinha, if we have quite a few questions, if we can extend the session by 10 minutes. Before taking questions, I'll just quickly conclude by saying that one needs to look at the contract comprehensively and see your rights and clauses under that. Engage with your counterparties, try to have a solution, and then if required, legal remedies has to be explored. And both you can look at the provisions in the clause, and also even if there are no clauses, there are benefits available under law, and that has to be explored, and there could be benefits under law as well, so that needs to be explored. I'll just quickly take a few questions, and then I'll hand over. Maybe we have to extend by 10 minutes. Sorry, we ran out of time.
No, that's okay. You can move ahead. Yeah, Vivek.
Thank you, Mr. Sinha. First question is from Mr. Hemant Jetwani. His question is basically, there was a party who defaulted in payment before COVID-19 period, and at this stage, he is now trying to renegotiate using force majeure as a reason to not pay, and there was no force majeure clause in the agreement. So what happens to a situation like this? Hassan, you want to take up?
Yeah, this is, Mr. Vivek, this is a very common exercise that many contracting parties are trying to take or to implement. Effectively, many force majeure related, let's say, contract amendments are not directly connected to COVID. So defaults are maybe before COVID context. So in this case, it is a straightforward assessment. If the default is not related to 249, which is a hardship clause, or even to 273, the judge will not implement it. it is something that will go through expertise, and if the expert determines that this default is not relevant, the obligations has to be fulfilled.
Okay. There is a question, from Mr. Jeevan Krishna. Can an owner encash the performance bond bank guarantee if the contract could not complete the construction due to COVID-19? So the question is, can a performance guarantee be invoked if there is construction not complete? To answer this question, bank guarantee or performance guarantee, it is a settled matter of law. It is considered as a separate contract between the bank and the beneficiary. So if the ground is there under the BG to invoking the guarantee, you could very well invoke the guarantee and the bank could be under obligation to pay. What happened because of the delay in construction because of COVID-19, that's a dispute which can continue between the principals. But as far as bank is concerned, there is no doubt under law it is required to make payment, unless of course there is a order from the court not to make the payment.
Yeah, in all the circumstances, it is possible to go for emergency decision and prove that there is no connection between the request and the context. But if it is clear that the bank guarantee can be liquidated without any reason, yes, in this case, I agree with you.
There's a question from Mr. Rajesh Agrawal. Can we rename or add the force majeure clause which covers such situation? I'm not very clear, but if you mean that in view of the current situation, can you amend the force majeure clause to add, say, COVID or pandemic in the agreement? I'm not sure if that's the purpose, but if that's the question, but to answer that purely depends upon the other party. If both the parties agree, then of course you could amend the clause the way you prefer. But in the current situation, we would expect one of the parties may not agree to an amendment unless it favors them as well. So to answer your question, any amendment would require consent of both the parties, and that needs to look at.
Yes. The other point is the fact that the force majeure has to be enforceable. So if the amendment is focusing only on COVID context, it will be difficult to activate it before the judge. It will be better to go for a more general formulation regarding the prospective effects of COVID. If there is a second wave or if there is other long-lasting effects of any pandemic or such health issues. It will be better usually to go for a wider description and to get disconnected from the specific context.
Yeah, I'll just take one more question, and maybe there are a few more questions. Maybe we can deal with that separately. And this is somebody, Mr. Naveed has said, is it better to use Article 273 to exit? Yeah, I mean, 273, the threshold is very high. It has to be impossible. And you could use that to exit the contract could be terminated if you meet the requirements. But I would like to highlight one point which perhaps we missed earlier, is regarding Article 249. I repeat, Article 249, which is about difficulty in performance, where court can get an order. That article in the civil code also says any agreement between the parties to the contrary is void. So that will apply irrespective of any clause in the agreement. So what I mean is, if there is a clause in the agreement that irrespective of civil law, if there is a difficulty, you have to still perform your obligation, such a clause in agreement is void. The civil code will override, and this will give the party a remedy if the court is convinced that the performance was difficult and one of the parties is under tremendous hardship because of the new circumstances. Mr. Hassan, you want to add anything?
Yeah, it's very clear. I agree.
Thank you. So with this, I'll hand over to Mr. Sinha, and I thank all the attendees for your time. Thank you very much. Thank you.
Thank you.
Yeah, Mr. Hassan and Vivek, I thank you very much for participating. Very insightful and very relevant topic which everybody is facing. So there were many questions which has still, because of the time. So we'll try to pick up those questions, Vivek, and get answers to individual members. Right.
Yes.
And see, we can provide these questions which are already on Q&A to yourself.
Yes.
And we will do that for the members. And thank you for all the members for attending. We had a very big attendance, and look forward to seeing you people in the upcoming webinars on interesting topics. Also, I request all of you from the letter I have sent to join the LinkedIn IBPC Connect group, as that's a good way to connect to everybody from the business networking point of view. So thank you, everybody. Thank you, Hassan. Thank you, Vivek, and good day. Take care.
Thank you, Mr. Sinai. Thank you, Mr. Vivek. Thank you for all the attendees. Thank you very much.
Thank you.
Thank you.
Thank you.